My lord, my lady, I appear together with Mr. Squires, Ms. Jones and Ms. Buchanan for the appellants, and the Secretary of State is represented by Sir James Eady, Ms. Giovanetti, Mr. Verderama, Mr. Popjoy and Mr. Booth. Before I embark upon my arguments, there are a couple of matters of housekeeping.
Yes, I'm aware of a couple of matters. Let's see if they're the same ones.
So the first was the supplementary statement, which
yes.
you will find an application in relation to that in the supplementary bundle, and that is.
Yes, this is the third witness statement of Mr. Kenyon.
Exactly.
Well, we've had a word about this. This is our position, subject to anything Sir James may wish to say. It seems to us that there's a good deal of force in the formal point which the Treasury Solicitor has taken, that this is in fact material that was not before the decision maker. Having said that, in order to see what it was about, I've read it, and I think the same goes for my lord and my lady. It doesn't really add much to the overall picture. I think we would be reluctant formally to admit it, but we are certainly aware of it and have read it to many essay. Is that good enough for your purposes?
That's good enough. The sole purpose is just to bring the court up to date as to where the position now stands with respect to repatriations, both by this country, but also elsewhere in the world, other nation states repatriating their own citizens. And the most important fact there that's referred to there.
If we're not going to admit it, you better not address me about the important facts in it.
Okay. Well, your lordship have it, and I would want to push that it should be admitted, just as so that this court can proceed on the basis of how things stand today. Whether or not you're then embarking on a review of the decision of the Divisional Court. So, put it this way, it does not make a difference in substance to the arguments, but it's just important background material that this court should have as to where matters stand.
Well, I think we're perfectly happy to have it as general background. It's simply its formal admissibility. I suppose, and you're making, maybe my first reaction was a little bit superficial, because we're not I don't want to spend time on this, Ms. Kaufman. Can we come back to it if it becomes important?
Yes, indeed.
Sir James, at the moment it's not admitted. Frankly, I don't think it makes very much difference whether it's admitted or not, but I think you're entitled to insist on the formal position for the moment.
Oh, I'm very grateful.
But you can come back to it if you think it's really important. Yes?
The second was our supplementary note, and
yes.
That is something that's not in the bundle, but was sent to the court some days ago.
Yes, I'm embarrassed to say I have got it, but I only twigged that I got it very recently, so I'm familiar with roughly what it said, but I haven't read it in any detail.
Could we leave it like this then? Can we see whether or not I get to addressing that by the end of today? And if I don't get to addressing it, then the court can look at it overnight, and perhaps you can look at it in more detail.
Yes.
And I can make an application
yes.
tomorrow.
Do you need an application? I suppose it's a bit of a cheat, because if you called it a supplementary skeleton argument, you would have had to get some permission for it. But it's really just another way of putting your case, which, unless it creates real difficulties for Sir James, which I doubt if he's safe to say that it does, we needn't have much of a fuss about.
No, there has been formal objection taken to it, but we would, of course, endorse your lordship's view that it doesn't actually present difficulties to the other side. It is just a further legal argument.
Well, then we'll have to hear, if Sir James says hand on heart that it does, then we'll have to take that seriously. But, and this isn't the time to have the debate. Certainly, in my case, I haven't read it fully, and I suspect we'll be better placed anyway to hear it, to make a decision once we're further into the case than we are now.
I'm grateful. So, unless the court itself had any further issues, those were the only two that I...
Well, there was just one point. That was one. I knew that there was the point about the witness statement.
You were asked, I think, the parties were asked, although I haven't actually seen the exchange, whether there was any problem about live streaming. Speaking for myself, I can't see that there is. There's no closed material. We don't know some piece of information which might be sensitive, like the names of C3 and C4. So there's no chance of us referring to them by accident. And I imagine the parties know what's sensitive and won't be referring to anything sensitive either. So that being so, I can't see why it shouldn't be live streamed. Right, live streaming will continue. Yeah.
So, can I just set out briefly where I intend to take the court by way of my submissions? I want to start by making some introductory remarks to, I hope, help the court by identifying where precisely we see the division lying between the appellant's primary case, that is the case not set out in the supplementary skeleton, on the one side, and the court's judgment on the other. I then want to identify, again from the outset, in the hope that it's going to help the court as we move forward, what doesn't appear to be in dispute between the parties. And then I'm going to move on to our case. I'm going to outline the facts briefly, if that is of assistance to the court. And I then want to take a careful walk through the authorities. There aren't that many that are key, but I do want to make sure that I take the court to all the passages in those authorities that we submit are relevant in establishing what is meant by control. And then I'm going to move on to the application of those authorities to the facts of this case. And that is, again, on the basis of our primary case, and to show the court why, in the light of those authorities, the respondent does have control over the appellant's detention, and in so doing, why this isn't a persuasion case, as the Divisional Court characterised it. I'm then going to move on to analyse the Divisional Court's judgment and make submissions on where it erred. And finally, I will seek to address the court on our supplementary case.
Thank you, that's very clear. I think the only observation I would have is
I think we think we're pretty up with the facts. There may be particular facts you want to make sure we're really up with, but I think taking us through the facts, even in headline terms, isn't necessary, except where there are ones you particularly want to emphasise.
I'm very grateful for your Lordship's indication. No, I will not then dwell on the facts, and as and when they come up with a need for particular emphasis, I'll just deal with them then. So the first point, to try to distill what sets the Divisional Court and the appellants apart, the court will have already picked up very clearly from our skeleton argument that our primary case is that on a proper reading of the authorities, and in particular Ramatulla in the Supreme Court, the question whether the respondent, a respondent, has custody over an applicant for a writ of habeas corpus is answered by whether that respondent...
Did you use the word custody advisedly, or was it slip for control? I thought the phrase was mostly used as
control, yes, or constructive custody.
Okay. Okay. No, maybe you did use it advisedly.
So,
Yep.
yes, constructive custody, or that is power and control over the applicant for a writ of habeas corpus, is answered by whether he has de facto the power to decide whether the individual should be kept in custody or released. Questions of obligation to secure that release, whether those are legal obligations or otherwise, or the circumstances in which such a power was acquired, are, in our submission on the authorities, irrelevant.
so what I missed the beginning of that. What is irrelevant?
Questions of whether the respondent is under some form of obligation, whether legal or otherwise, to secure the release, or questions as to the circumstances in which such a power was acquired to secure the release are irrelevant for the purposes of the writ.
And can I just flag up one point?
We're talking about the release, and of course in most cases that's all one's ever really concerned with. But it is, formally as I understand it, release and production to the court. And in a case within the jurisdiction, two go together. But it's not so clear here. They procure release literally simply means the doors of the camp are opened and they can wander around northeast Syria. Clearly more than that is required.
And what
Yeah.
I'm going to, when it comes to what's not in dispute, I will make it absolutely clear that we do not dispute that in order to secure the release, given the conditions that have been laid down by the AANES, it would be necessary not only to say, please can we have them, would you release them, it will be necessary to repatriate them. I just want to make, I will make clear in a moment, we don't dispute that. So release here on these facts means release by way of repatriation or agreement to repatriate. So,
Sorry, I'm so sorry to interrupt, Ms. Coughlin. Before we go on, can I just start? You talked about question of legal obligations of the respondents. Do you mean legal obligations of the respondents or of the custodian?
no, I mean of the respondent.
You do mean of
I mean of the respondent. Whether there is a legal obligation or some other form of obligation that doesn't actually have a legal colour, that is irrelevant. Now, that analysis, our primary case, was rejected pithily by Lord Justice Lewis at paragraph 108 in the core bundle at page 95. And I just want for us to look, before I go into any of the arguments, how the Divisional Court put it so that we can have these well in mind as we then go through the authorities. So at paragraph 108, and that is page 95 of the core bundle, halfway down the paragraph, there is a line starting control their custody, and then the following sentence, that's about halfway down the paragraph of paragraph 108. Secretary of State may be able to facilitate or help bringing about the applicant's release if he were able and willing to do the things required by the AANES authorities before they will release the applicants from the camp. As Mr. Justice J explains at paragraph 91 and following of his judgment, the ability of the Secretary of State to respond to the conditions fixed by the AANES authorities for release of the applicants does not, however, mean that he has custody or the control of the custody of the applicants. We will come back later in detail to the next passage that I'm going to take the court, next passages I'm going to take the court to, but can we move then on into the judgment? It actually means moving backwards in the judgment to that of Mr. Justice J, and to paragraph 77 on page 89, because in reviewing these passages, we will be able to see why it is that they consider de facto control is not sufficient. So, paragraph 77 on page 89, if the court can read 77, 79 and 80. And what the court is here addressing is the Ramatulla judgment in the Supreme Court and the basis upon which the circumstances of that case differed in the Divisional Court's view critically from the circumstances of the present case. and that does capture the position at the very bottom of paragraph 80. So Mr. Squires is constrained to argue, well, we would say not constrained to argue, Mr. Squires argues on the basis of the authorities, that the present case is not an exemplification of persuasion or the taking of diplomatic moves, but of the coercive power of the law as applied through the portal of habeas corpus and nothing else, compelling the Secretary of State to react to the unilateral offer. So to put it simply, if we are correct and the test is one of de facto control, then it does follow that once de facto control is established, then the force of the writ does the rest of the work. The force of the writ, if issued, has the consequence that the respondent to that writ must bring the person before the court, that is, secure the release, or if that proves not to be possible, come to the court and explain why. We can next turn to paragraphs 91 to 94, and that's the reasoning. It's here that we find...
I'm trying to resist and will resist the temptation to have the main argument with you now, because you're basically flagging up points. This, you'll be coming back to this.
Oh, absolutely. So this is just to set out, this is where the division lies. That is what we say the authorities established, and then I've got to make good that case. Now, I'm going to do that by taking the court through the authorities. I just want the court to know before I do exactly where the dividing lines lie.
I just wanted to be reassured. We'll
yes.
have
No, we will come
engage with you on this.
We will come there, and then you can ask as many questions and destroy my argument as much as you
going.
wish.
Test your argument is the most we'll do.
So 91 to 94, if the court could turn to that, that's page 92. Can I ask again the court just to read those passages for yourself?
91 to 94.
91 to 94, starting at page 92.
Yeah.
We're going to come back to these paragraphs and the rest of the paragraphs that follow later on, but because they're difficult and they require repeated reading. But an attempt to distill the essence of Mr. Justice Jay's reasoning, both in paragraphs 77, 79 and 80 and here, is this: that the respondent is a custodian or has control for the purpose of the writ only if the power he possesses de facto to bring about the release, so that's obviously a necessary condition, not sufficient, so only if the power he possesses de facto to bring about the release of the applicant is one that he is A, under an existing obligation to exercise, whether that be legal or otherwise, and or the power is one that has been voluntarily...
Is that and or B, is that?
And or B, I apologise. And or B, the power has been voluntarily acquired in the sense that the respondent had dominion over its acquisition.
Didn't understand that. But
So the term dominion is something that I take from the passage your lordships have just read. But if we put that aside, it has to be a power that has come to the respondent voluntarily,
So by choice or agreement.
by choice or agreement. So that's the division between our primary position. It is a de facto question of de facto control alone, capability or having the power that gives the respondent the ability to secure the release, or something which is actually more complicated than that, and which involves the two elements either in conjunction or one or the other that I've just described. Now, I accept that the Divisional Court never explicitly states that there must be some such obligation or voluntarily acquired power, and in fact it does, in places, disavow the laying down of any rigid criteria. But in my submission, its judgment is ultimately only comprehensible on the basis that this is something that is required. Now, that may not be exhaustive of the circumstances in which the writ might issue in respect of somebody who is held abroad, but it is certainly necessary in cases such as the present case. And in our submission, the way in which the Divisional Court has put the case is not faithful to and does not reflect the authorities. So can I then move on to the matters that don't appear to be in dispute between us, so that the court can be clear about the way in which we do put the case. There was, as you will have seen in reading the Divisional Court judgment, there was an issue as to whether or not UK officials would need to be involved in any steps to repatriate the applicants. And the Divisional Court held, just for the court's pen, at 25 to 26 and 28 and at 35 of the judgment that the AANES would expect the UK government to occupy centre stage in any repatriation, and that was relevant to the question of whether or not Reprieve, for example, could come along and do the lion's share of the work in repatriating the appellants. We proceed on the basis on which the Divisional Court found the fact, that is, that the AANES will not release the appellants unless, one, they are repatriated, and two, that is done by the United Kingdom.
oh, hang on 1 second. That second way of putting it is a bit of a shorthand, but in view of what you already accepted, I think, saying that they are repatriated by the United Kingdom means more than simply issuing emergency travel documents. It means someone with consular authority turning up at the handover point and taking charge.
Yes, exactly. Taking all
AANES won't then mind if, 100 yards over the border, the UK government subcontracts to Reprieve, but the key point is they have to take charge of the repatriation in person.
Yes.
Take charge, of the handover in person.
Yes. Of the process of repatriation, that has to be undertaken by the United Kingdom, not private persons such as Reprieve. So the second issue that doesn't appear to be in because we take the Secretary of State's own words here and explanation, is the reason why, to put it in the way that the Secretary of State did, the Secretary of State has refused to provide consular assistance. That is, refused to undertake those steps which would lead to the repatriation of the appellants. And that is, again, for the court's pen, that's set out in the letters from the Secretary of State of the 17th of June of 2022. SB tab 9, supplementary bundle tab 9, page 304 and page 313, dealing with the C3.
What's the date of the second letter?
They're both dated the 17th of June. So that one's written in relation to C3 and the other in relation to C4. And that the reason is national security. And that's again confirmed in the witness statement, again for your lordship's pen, of Mr. Hargreaves, supplementary bundle page 117, paragraph 20. The Secretary of State decided not to assist the applicant's repatriation on national security grounds, given that they travelled on their own.
It's what is this Hargreaves 1, is it?
This is in Hargreaves 1.
And what para did you say?
Paragraph 20.
Yes. You don't need to comment on this, but can I just flag up with something that Mr. James may want to address later? I too had certainly seen that and understood that to be the statement of the Secretary of State's position. I don't quite know how that fits in with the recitation of the practical difficulties of both a logistical and diplomatic nature involved in accepting the appellants at the handover point, wherever that might be, and taking them effectively to an airport. Yes. I'm not sure whether that is being advanced as a separate reason. Formally it isn't, but I just want to know where it fits into the argument. I'm looking at you, but I'm really just flagging up a point.
Yeah.
It's not necessarily a criticism of the Secretary of State's case. I just want to understand where it bites.
So our understanding of the explanations the Secretary of State has given and the state witness statements is the reason is national security. There are also practical considerations that have to be taken into account in repatriating anybody, and then it's necessary to liaise with other nations in order to secure the repatriation because of the need, for example, for them to pass out of Syria into Iraq. So definitely there are practical considerations, there are considerations of, or rather there are matters of international relations that have to be addressed in order to give effect to any repatriation. But our understanding is the reason for refusal is national security. And in that respect, it is important to note, and this isn't set out in this new witness statement, although there is an additional individual who was brought back, whose case is addressed in the witness statement, the Secretary of State has historically already taken those practical steps in relation to children who have been brought back. And of course, those practical steps have been undertaken, and the liaison with other states has been carried out in many hundreds, in fact thousands of cases by other nations.
Well,
so
I understand why you make that point, but I don't think the Secretary of State has ever said it's impossible.
No.
But weight is nevertheless placed on the practical complication and difficulty of doing it. And we'll hear later where that fits in.
Exactly. In our case is absent impossibility, in which case there is no control, then those practical considerations and matters of international relations are not relevant to the issuing of the writ and to the question of control. That is our case.
Okay, hang on 1 second.
And on that point of numbers, the court has in the bundles the reports from the RSI report, which shows that in Annex 2 of that report, or Annex 3, sorry, of its November 2020 report, together with the updates that have been provided in the witness statement, Anne McMurdo particularly, her second witness statement, that we count in total that about 1,200 women have been repatriated, together with many, many, many more children, by a very, very substantial number of states, including, as I say, the United Kingdom, and recently, in October, a woman and child. So the third matter, not in dispute, is for the purposes of this hearing, is the legality of detention. As the respondent has said, that is not an issue for the purposes of this appeal. Now finally, just before then turning, I think I can go straight to the authorities after this, before turning to them, can I just clarify the basis upon which we submit that the Divisional Court erred in refusing to issue it in one particular respect?
Okay, does this come under the heading points not in issue, or is this a sort of...
No, this is a final point of clarification. Sorry, I've completed my points not in issue.
Couldn't matter at all, but just so that I don't mess up my note. Yep, okay.
Just a final point of clarification. So it is not, we don't complain about the Divisional Court's judgment on the basis that it concluded it was wrong in failing to conclude that there was a reasonable basis to believe that the respondent had control, and such that the writ should issue so that the respondent could explore the question of control and produce the body if it turned out it did have control. Our position is that on the basis of the material before the court, the agreed material, that which is not in dispute, the respondent does have control.
So I'm not sure I've fully understood that, but I think now I've got to the end. Is it really simple? You're saying you're not arguing for a halfway house?
No, and in fact the halfway house is in one sense neither here nor there, but most recently, these cases have proceeded on the basis that there is reason to believe there is control, but it's just not known how the detainer is going to respond. So it's necessary to issue the writ so that if control does exist, the person can be brought back, but part of the purpose of issuing it is so that the very question of whether the person has control can be explored. And we submit that's not the position here. There is, on the basis of the material before the court, in our submission, no reason to doubt that the United Kingdom has
Well, I see that.
control.
Well, we better wait and see. But I mean, it's not impossible that we might take a different view about that. We might say there was some doubt, but we were in the same position as the Court of Appeal in Ramatulla. You presumably,
And then I say,
you take that.
I would
That's not your
absolutely
case.
take that. I
Yeah.
would say, if there's any doubt, then certainly we've met the conditions in Ramatulla and O'Brien where there is reason to believe. But we submit there isn't any doubt here. And I'll come on to why we submit the court can be quite clear in this case that the UK does have control and can bring these women back here and secure their release.
Well, it's the other way round, isn't it?
Sorry?
It's the other way round, isn't it?
What, can secure
Release
their
is
release
first
by
and
bringing them back here?
is second.
I'm sorry?
Well, release is first and bringing them back is second. I think you were
Yes, but
suggesting that
securing their release is by bringing them back. That is a condition. That is the condition. And in our submission...
Can I just I decided not to follow it up first time you said this, but I think I will now. You accept that on the facts of this case, release also means repatriation, because that is the only condition on which AANES are offering release. Suppose they hadn't said that. They said, we will release them, and either once we've released them, we don't care where they go, or we will release them to you, and as long as they can't go outside Syria, we don't care where they go, you don't have to take them home. Is it not in the nature of habeas corpus, quite apart from any conditions they might have imposed, that there is an obligation to bring them back into the jurisdiction?
So the writ, in its origins, required that the detainer produce the body before the court. That was an aspect. As it's developed in modern times, what has sufficed is for the release to be secured and for the respondent to come back on the return of the writ and tell the court that it has now secured the release, without the requirement that the body actually be produced before the court.
Okay. Yeah, well, you'll show us that when we go through the authorities.
Yes, so for example, O'Brien, I think, is an example of that. We'll see, I think, in the end of the judgment in the High Court, that's exactly what was recorded to have happened. So can we then turn to the authorities?
Yeah.
So a basic feature of habeas corpus is that the jurisdiction to issue it is dependent upon the respondent being within the jurisdiction of the court and not the applicant. And that is, we can see from Lord Sumption's speech in Sirda Mohammed at 18 of the authorities bundle, page 970, paragraph 101.
These in every respect are well put together authorities bundles, except that they don't say on the back which tabs are in which bundle. So which tab did you say? 18?
It's tab 18.
Which bundle is that in? I can mark them up.
I'm very sorry, my lord. Perhaps
3, I think.
Look, I'll just do that quickly.
Yes.
So, I think bundles are put together these days by people who only have a look at the documents electronically and don't appreciate the practicalities of those who are still looking at them in hard copy. But anyway, I'm nearly there.
I'm sorry, my lord.
No, it honestly couldn't matter less. But okay, it's in bundle 3.
So bundle 3. And it's page 970, paragraph 101. And if the court would just read that paragraph.
Yeah.
And then we're going to go right
I
back.
will just read to the end, but it's really only the third
It is.
sentence.
And then from there,
Yeah.
I'm going to go right back to the beginning of the authorities bundle to the first authority, tab 1, and this is the Bernardo case.
Yeah. Okay. One second.
Page 3. Can I ask the court just to read the head note? very short, and the two holdings.
Yep.
And then, if the court can turn to page 339, internally, I'm sorry, that's page 16 of the bundle. And this is in Lord Herschel's judgment. And the part is marked up, I hope, for the court at the bottom.
Yep.
And then if you have got to the end of the first line, the first sentence on page 340 internally, on the next page.
Yep.
And then you go from there to Lord McNarton's judgment, and starting with I do not dissent from the motion which has been proposed, and then just the next 5 lines. Ascertaining beyond all doubt whether the child is or is not still under Dr. Bernardo's control or within his reach. And then if we move on to page 18 and Lord Hannon's judgment, just the first 4 lines, I entirely concur in the conclusion at which your lordships have arrived, and I have only to add that the opinion expressed by my noble and learned friend Lord Herschel so exactly represents the view which I take of this case. And then from there, we move on to
Out of curiosity, why you take as Lord Hannon but not Lord Morris?
Oh, I'm sorry.
I don't mind at all.
And Lord Morris, yes.
Yes,
So,
the only point is that those two didn't say anything
they didn't say anything.
Yep. Okay.
So then, if we can move to the O'Brien judgment, which is tab 2. First instance, and again, can I ask the court to read the head note? Without the holding, just gives the court a sense of what the facts were here. Sorry, yeah, Court of Appeal. And next, if the court can turn to page 49 internally, page 391 in the judgment of Lord Justice Scrutton. And again, the relevant passage is marked up. Focus is very much on the question of whether, as a matter of fact, there is control. And if we move into the judgment of, so if the court has read through down to page 392, 4 or 5 lines down, ending on the sentence, we have a complete control over the position in which the internees are placed. And then in what follows there on that page, Lord Justice Scrutton continues to address the conflicting evidence that there is. And if you then pick up again in the marked up passage on this conflicting evidence, all proceeding from the Home Secretary himself, it appears to me quite doubtful whether or not, if an order is made for the protection of the body, the Home Secretary can or cannot produce that body. Under these circumstances, I think the proper course to follow is that affirmed by the House of Lords in Bernardo and Ford. And there, Dr. Bernardo alleged on oath that before the issue of the writ, he had parted with the body to an independent person, that he did not know where the person or the body were, and he had no means of communicating with them. The applicants disputed this on various grounds, and the House of Lords affirmed the order of the Court of Appeal and ordered the writ to issue in order that a return might be made to it, on which return the truth might be ascertained. It may be that on hearing that in the opinion of this court the order was issued without legal authority, the Home Secretary, with the assistance of the Irish Free State, will produce the body, as it is hardly in the interests of either government to act illegally. For these reasons, I think that the rule should be made absolute for the writ to issue on the terms of the rule nisi. And what that means, if it's absolute, is that the respondent is required to secure
So
return.
this doesn't affect the authority of it, but a great chunk of the reasoning, which I haven't read, but was evidently
On the prior question of whether the original detention was unlawful.
Well, we'll come on to that because there is an observation about the significance of that.
But that, I'm right as a matter of fact. I thought one of the things the Court of Appeal had to decide, or maybe presumably first decide in the first instance, was whether the original detention was unlawful.
Yes.
That's implicit, isn't it, in what
But it's not.
Lord Justice Strutton says that the court, on hearing that in the opinion of this court, the order was issued without legal authority.
Yes,
But that's an opinion already expressed, isn't it?
Yes, but can we just continue through?
Yes, sorry.
Because that matter, the legality or otherwise of the original detention, is not what was decisive. Lord Atkinson, who dissented.
You mean Lord Justice
I'm
Atkins?
sorry, Lord Justice Atkins. I suddenly jumped into the Supreme Court judgment on my notes. So page 398.
Yes.
Which is page 56. I'm sorry. And I'm sorry if the court would just bear with me. My
No problem.
abilities to manage my own electronics is failing me badly. So if we turn, yes, to page 56, and this passage is marked up,
Yeah.
and if the court will read right to the end of where it's marked up.
Yeah.
And you can see the question, in testing the validity of the order, this is right at the end, in testing the validity of the order, the question is as to the legal right to control. In testing the liability of the respondent to the writ, the question is as to de facto control. In all cases of alleged unjustifiable detention, such as arise on applications for the writ of habeas corpus, the custody of control is ex hypothesi unlawful. The question is whether it exists in fact. So the focus in relation to control is one of actual control, irrespective questions of illegality. And then, if we can go to the bottom of that page, and the next bit that is marked up, The affidavit states that the applicant is in the control of the governor of the prison and is not subject to the Home Secretary's orders, but this is by no means inconsistent with an agreement with the Free State government to return on request. I think, moreover, that the applicant strengthens his case by reference to the debate in Parliament, which is then addressed. And over the page, 3 lines down, the order is that the applicant shall be interned in the Irish Free State and shall remain there until further orders. It was conceded that the ordinary interpretation of these words would be until further orders by the Home Secretary, though it was said that in fact he had no power to give such orders. I cannot, without further explanation, accept this. So, if you then move to the bottom of the page, after the italics rule absolute, we can see that the writ of habeas corpus was sealed on May the 10th. So that was the moment at which the respondent was required to produce the body, and the notice which accompanied it required the Home Secretary to make the return of the writ and have the body of Mr. O'Brien before the Court of Appeal on the 16th of May 1923. On the last mentioned date, the Home Secretary, in obedience to the writ, returned that Mr. O'Brien was taken on March the 11th in pursuance of an order made by him dated March the 11th under the restoration of order in Ireland regulations, and in pursuance of such order was interned in the Irish Free State. He produced the body of said O'Brien in court and he was discharged. So he was actually produced in that case.
Yes.
But then...
We don't know what the technicalities of, what the actual practicalities of that were. He was interned in Kilmainham Jail, or wherever it was, Mountjoy. My lady reminded me before, we were discussing it before. So presumably, well, we don't know, the Home Secretary made arrangements, put him on the boat.
One assumes so. We simply don't know.
We simply don't know.
I mean, he could have said, look, you've got to turn up in court on the 16th, but it's unlikely that he wouldn't have facilitated his arrival at court on the date of the return of the writ. But again, for our purposes,
indeed, strictly speaking, it may not matter, but it just illustrates that the issue which arises in this case, or the complications which arise in this case, in practice didn't arise one way or another. It wasn't very difficult to travel from Dublin to London. And we don't know who paid the bill, or
we don't know whether they arose or not. But again, in my submission, that's neither here nor there. If we are correct on what constitutes control.
No, I understand that.
So the matter then, before the return date, actually went on to the Supreme Court, and your lordships and my lady, that's at Authorities tab 3, page 59, and the court only needs to read the first paragraph for the holding. So the court will see what was in issue before the House of Lords was whether or not an appeal lay where the court determines the illegality of the applicant's detention and his right to liberty, although the order itself does not direct his discharge. That was the question for the Supreme Court. And they held that, for the House of Lords.
So sorry, I've got a little behind. Where were you reading from?
I'm reading from the top of the head note,
yes,
in the House of Lords, where we can see what the issue was, and that the House of Lords held that in those circumstances no appeal does lie from an order of a competent court for the issue of a writ of habeas corpus.
No appeal laid to the House of Lords.
That's as things stood at that time.
Yeah.
But just for completeness, if the court can turn into the judgment of Lord Atkinson, who dissented, who did believe an appeal lay, and his reasons are, on that point, not ones that we need to focus on. But on page 80 of the bundle, if I can ask the court to read the part that is highlighted.
get from that?
So, firstly, one can see the coercive power or the coercive force of the writ. If issued, it compels the Secretary of State to produce the body in court or secure the release in modern times. And secondly, we can see at the bottom 4 lines, the use of the term power and control. The factual question. If the Irish executive should fail to help him, he would be placed in a very serious position. Unless this executive breaks what has been styled its bargain with the Home Secretary, he had, in effect, the respondent under his power and control. I.e., if as a matter of fact, the bargain is kept, then he will be able to secure the release. So, can we turn next to the authority of Moenya, which is in tab 4, starting at page 103. And again, if I can just ask the court to read the head note until number 1. Get a sense of the...
Up to and including number 1?
No, up to number 1, not including number 1. And then on the next page, to the holding, allowing the appeal on the first point that the jurisdiction to issue the writ of habeas corpus.
Which was the first point?
Sorry, it's held on the.
Well, it says holding the appeal, allowing the appeal on the first point,
On
which
the
was
first
the first.
point.
Which was the first point?
Oh yes.
What was?
So the first point was whether the court had jurisdiction to issue the writ, but that will become clear from.
I see. Sorry.
The jurisdiction to issue the writ of habeas corpus was not limited to territories outside England, which were strictly called colonies or foreign dominions, but extended to territories which, having regard to the extent of the dominion in fact exercised, could be said to be under the subjection of the Crown, and in which the issue of the writ will be regarded as proper and efficient, that if upon a proper investigation of the facts it appeared that the internal governments of Northern Rhodesia was in legal effect distinguishable from that of a British colony or country acquired by conquest, then in conformity with the nature of the writ, there was no reason for denying the jurisdiction of the court to issue. So the issue there was whether the writ could run at all in what was a protectorate as opposed to a dominion. So not an authority looking in detail at the question of control, but looking at a prior question as to whether or not it can run at all. Before we look at the Court of Appeal judgment, can we just look briefly at the judgment of Lord Parker, because this is where the term constructive custody, I think, was probably first used. It's a term that was later picked up by Lord Reid and Ramatulla, as we will see later. If the court can turn to page 141 of the bundle, internal page 289, and at the bottom of that page,
279.
I'm so sorry, yes, 279. At the bottom of that page, the paragraph starting the position here is quite different, and if you you start from 4 lines down, no doubt the writ will issue not only to a person who has the actual custody, but also to a person who has the constructive custody, in the sense of having power and control over the body. Here, however, we could find no custody by the Secretary of State in any form, and we will refer to a large number of provisions of the Constitution of, and in other legislation in regard to, Northern Rhodesia, under which the Secretary of State is specifically given certain powers, and powers which extend beyond advice. But we find it impossible to say that as a result of those powers, he could be said to have the custody of the body in any sense. Apart from the powers given by such legislation, the only power of the Secretary of State arise by reason of his constitutional position under which he advises Her Majesty. The fact, however, that he can advise and attempt to persuade Her Majesty to cause the body to be brought up does not mean that he has such control as will enable the writ to issue. Nor is it, in our view, relevant that if the writ were issued, the Secretary of State might well feel it proper to influence the production of the body. Accordingly, while agreeing that there may be special circumstances in which a Secretary of State is amenable to the writ, we can find nothing in the facts of this case which could justify us in calling upon him to produce the body. That being so, we intimated our decision to that effect and thus made it unnecessary to proceed further with the case. So we can see there, Lord Parker looking at the sorts of factual features which fall short of control, but are in the nature of an ability to persuade or influence. Can we then turn to the Court of Appeal judgment and to the judgment of Lord Evershed, Master of the Rolls? That's on page 165. In conclusion, then, this is the second paragraph down in the page. In conclusion, then, I do not attempt anything in the way of definition which would or might provide the answer to other cases, beyond saying that the jurisdiction ought not to be limited to territories outside England which are strictly labelled colonies or foreign dominion, but will extend to territories which, having regard to the extent of the dominion in fact exercised, can be said to be under the subjection of the Crown, and in which the issue of a writ will be regarded as proper and sufficient and efficient. And then, albeit that this is looking at the prior question of control and looking about whether the writ can issue at all, the focus of the court is on whether or not there is something that can be achieved by the issue of the writ. Is it proper and efficient? Because if in fact there is no jurisdiction of the Crown over the territory in question, or the circumstances, then plainly it is not proper or efficient for the writ to issue. But it is a factual question, not a question of the legal characterisation of the territory in question as a protectorate.
Well, I don't doubt if it's going to be central to your submissions, the phrase proper and efficient, but if it were, I think we need to see the judgment of Lord Mansfield from which it came. So on one view, this is simply a common sense finding on the facts that just because Northern Rhodesia was a protectorate and not a colony, nevertheless in practice the Crown, through the Roman Secretary of State, had power to say what happened there.
Can we see nonetheless what the rest of the judges have
Yes, certainly.
said in relation to this particular circumstances they were concerned with? So next is the judgment of Lord Justice Romer on page 167. If the court will go to the very bottom of that page and to the last two lines up, at the end of the line, starting for myself, I do not believe that the right of the sovereign to inquire into the liberty of her subjects depends on the narrow distinction between territory which is part of Her Majesty's dominions in substance and territory which has become part of her dominions in fact by a formal act of annexation. The question whether the writ can issue does not, in my judgment, depend upon such a distinction as that, but on the propriety and effectiveness of issuing it. The propriety and effectiveness of issuing it into Northern Rhodesia may have to be decided hereafter, but the purpose of considering the validity of the Crown submission, but for the purpose, of considering the validity of the Crown submission, it must be assumed that in the case of some protectorates, the issue of the writ would be both proper and effective. Again, it's looking at what could practically be achieved by the writ in the particular circumstances. And then in the judgment of Lord Justice Sellers at page 170, the court can go and start from page 308 eternally, the second paragraph up from the bottom. There may come times in a country's history when it may appear highly inconvenient or politically hazardous that the law should pursue its course. But in a court of law, such considerations are irrelevant and cannot serve to deprive a subject of a right which an English court could give and enforce. Ex parte Anderson is perhaps the most striking of the cases where the writ of habeas corpus has issued from an English court in respect of a detention outside the territorial boundaries of England, but within Her Majesty's dominions. In that case, Canada. The case was only argued on one side, and at least two of the judges later tended to minimise its effect, but it brought about the Habeas Corpus Act 1862, which provided that no writ should issue out of England into any colony or foreign dominion of the Crown, having a court competent to grant and issue the said writ and to enforce it. In addition to the authority of ex parte Anderson, this statute would impliedly indicate that the writ would lie within Her Majesty's colonies and foreign dominions if no such court existed. And I don't understand the Crown to have submitted otherwise. The submissions of the Attorney General and Mr. Cumming-Bruce was that there was a strict territorial boundary which was conclusive as to the scope of the writ. If this restriction had, throughout history, always been the confines of England and the normal territorial boundaries of the court, the argument would have been compelling. But once the writ has gone beyond our shores, as it has, and outside the normal jurisdiction of the court, why should the writ be limited by territorial boundaries? The writ is concerned with personal freedom, and the emphasis, in principle, it would seem, is not on whether wrongful detention is occurring, but assuming the court is satisfied that the detention is without justification, whether it can, having regard to the proper interests, rights and powers of those governing the place of detention, make an order which can be enforced, and so release an applicant who has asked for justice before it. That's, again, a very strong endorsement of the practical purpose of the writ.
So, we don't know, but I asked simply to illustrate the point where the court in England makes an order for the release of someone in Canada. Did the writ require that they be brought back from Canada by the detainer and produced to the court in this country?
So in those
quite
days,
a serious journey in 1860.
in those days, the writ would require the respondent to produce the body before the court.
And who would pay?
I am afraid I don't have the answer to
No.
that.
I'm just teasing out what actually happens with the practical difficulty of bringing someone back from a foreign jurisdiction or from a foreign country, maybe. Anyway, thank you.
We'll see a little bit more about this in Ramatulla.
Yeah.
I mean, our submission is that is not a concern of the court. The writ issues and the job has to be done. The writ must be executed unless it's impossible to do so, or there is some sufficient barrier that the court is then satisfied that actually, as the facts have evolved, it is not in the control of the respondent to produce the body. Can we then turn to Sanko? This now is very much a persuasion case. And we begin to see the distinction between a situation where there is facto, the ability to produce the body, the power and control over the body, and something less than that, where the writ will not run. So in Mr. Sanko's case, he was detained by Sierra Leonean forces in Sierra Leone. And the United Kingdom had a presence in Sierra Leone on the ground, and at the invitation of the Sierra Leonean government, at the request of the government, it provided transport to move Mr. Sanko. And it actually did this on 2 occasions in close succession. And thereafter, and before an application was made for the writ to issue, Mr. Sanko was moved again without the assistance of the United Kingdom. Now, at first instance, the judgment was given by Mr. Justice Elias, and if I can ask the court to turn to paragraph 22, page 180 of the bundle. And on his behalf, submissions were made from extracts in speeches made by the Foreign Secretary. We can see that from the previous paragraph in Parliament, and Mr. Peter Hain. Mr. Engelman then, at paragraph 22, made a number of submissions demonstrating the following. Firstly, that the United Kingdom forces are in Sierra Leone in pursuance of an agreement between the UK government and Sierra Leone. Secondly, these forces were called upon to assist the police and army in Sierra Leone in the arrest and transfer of Mr. Sanko. Thirdly, at all times the UK government has been what the Foreign Secretary has described as a principal supporter of Sierra Leone. Fourthly, they've made it plain that they want to ensure that Mr. Sanko is brought to justice. Fifthly, there is evidence from Mr. Hain in particular that assistance has been given to training the military authorities in Sierra Leone, although it's relevant to point out that it appears that a request from the President of Sierra Leone that Brigadier Richards should become the Sierra Leone Chief of Defence Staff was not considered acceptable. And then we see at 23 to 24, if the court just flicks through, some further emphasis that Mr. Engelman put on the speech of Mr. Hain. And then if the court goes to paragraph 25, what Mr. Engelman says...
Hang on 1 second.
And then of that, it is said at paragraph 25, Mr. Engelman says that language suggests strongly that Mr. Hain was indicating that the British government were in a position where they could, if they wished, trade Mr. Sanko for the hostages. And Mr. Justice Elias then says at paragraph 26, I accept that the material relied upon by Mr. Engelman does broadly reflect the first 5 points. The question is, however, whether they arguably demonstrate de facto control over detention so as to justify the issuing of the writ. In my judgment, they plainly do not, and not even arguably so. There is no evidence which approaches the sort of material which justified the inference of de facto control in the O'Brien case. Moreover, in my view, it would be extremely surprising if the Sierra Leone government were to concede to the United Kingdom the right to determine when and where Mr. Sanko should be detained. He is a Sierra Leone citizen who is wanted by the Sierra Leone authorities for breach of the Sierra Leone law. It is difficult to see why the Sierra Leone government would be willing to enter into an agreement to concede control to the United Kingdom. And then at 28, I quite accept that the United Kingdom government may have political influence, and perhaps significant political influence with the government of Sierra Leone, but that, in my view, falls very short of constituting the kind of de facto control necessary for a writ of this kind to be issued. And then he turns to Moenya, where it is said that some support can be found for this, and we can see that he cites at paragraph 31 the judgment of Lord Parker that we looked at. And at 32 to 34, if I can invite the court to read those passages.
Yes.
That then was appealed, and the judgment of the Court of Appeal is in tab 6. And the appeal was dismissed, and we can see at paragraph 12 in my judgment, there is not a whisper of an objective basis for the suggestion the Secretary of State has now or had at any time from July 2000 onward anything amounting to a degree of control over Mr Sanko such as might justify the issue of the writ. The case on its facts is wholly unlike the case of O'Brien, to which, as I have said, much reference was made. And the other judges then agreed. Can we then turn to the case of Ramatulla? And we've got the judgments of all three courts, and we will look at passages from all three judgments. But perhaps to get a sense of the facts, it's sensible to start with the judgment of the Supreme Court and then go back to the judgment of the Divisional Court. So the Supreme Court's judgment's at tab 12. If the court could just read the first 10 lines or so of the head note up to the 2009 MOU.
Yeah.
So the United States had made clear that it did not consider that the Geneva Conventions applied in the context of people like Mr. Ramatulla's activities and capture. And as for the requirements of the Geneva Conventions, can the court turn to paragraph 37 of the judgment, page 437? And just read what it requires.
Just give me 1 moment, sorry.
Page 437, paragraph 37.
Yes. Yeah.
So the important point being that it obliges the transferring authority to request the return in circumstances where they have reason to believe that a person transferred is not being treated in accordance with the Geneva Conventions, and then an obligation upon the power that is receiving or has received the individual to release them on request. Now, as I said, the US did not believe that the Geneva Conventions applied, and hence an MOU was entered into. And we can see more about that at paragraph 8 of the judgment, page 431. And then at paragraph 11, it's common case that the 2003 MOU is not legally binding. It was, said Mr. EDQC, who appeared for the Secretary of State, merely a political arrangement, but its significance in legal terms should not be underestimated. It doesn't depend, its significance, on whether the agreement that it embodies was legally binding as between parties. And he cites Lord Neuberger, and we'll go back and see that in Lord Neuberger's judgment. But there was a later agreement, a 2003 8 MOU, which it was argued by the Secretary of State actually superseded this, and therefore the 2003 MOU didn't apply. We don't need to concern ourselves with that because the court ultimately considered that the 2003 MOU continued to have application.
Yes.
So that's the factual situation. If we can then go back, just want to touch very briefly upon the Divisional Court judgment for two reasons. Firstly, because of the Secretary of State's position as set out in those proceedings, and secondly, because the Supreme Court's judgment differed from the Divisional Court, and it's relevant to see how the Divisional Court put matters in order to understand the significance of the different view taken. So, can I turn then first to the judgment of Lord Justice Laws at paragraph 30. And can I ask the court to read paragraph 30?
Yep.
And importantly, thus as Mr. Eady accepted in the course of argument, there might be sufficient control if it were demonstrated that the relationship between the respondent to the writ and the actual custodian was such that a request by the former for the prisoner's delivery by the latter would plainly be acceded to. De facto or de jure, however, the respondent's power must be actually to deliver the prisoner or in effect direct his delivery. And we are content that that represents the position. It's a de facto power to deliver. Then your lordships will see that the court began to consider the Moenya judgment, but can I make clear, not the passages that we have looked at just earlier, but a passage that I know the Secretary of State...
Sorry, just one moment. Yeah, carry on.
So there is passages there that were considered that certainly the Secretary of State is going to rely on, as I understand it from his own written submissions. But if you follow that down to paragraph 32, the reasoning of the Court of Appeal in Re Moenya shows that the factor which restrains the issue of the writ to a land beyond the seas is not any formal rule as to the territory status, but the presence or absence there of power or control in the Crown. In Lord Mansfield's words, the issue of the writ must be proper and efficient. And from there you go down to paragraph 33. In the present case, it is plainly not suggested that the writ should issue to Afghanistan, but that, of course, is where the claimant is, and he remains in the hands of the Americans. As I've made clear, the case advanced is that the pressure of the writ be deployed not to test the truth of evidence adduced on behalf of the Secretary of State, or to elicit further evidence, but to require a request for the claimant's release to be made to the American authorities and to test their response. Now, we have full evidence of what the arrangements with the Americans were. The case is therefore quite unlike Bernardo's case, or Ex parte O'Brien. Those arrangements do not, in my judgment, establish power and control in the hands of the Secretary of State, such that the issue of the writ would be proper and efficient. Far from it. First, he has no legal power to direct the claimant's release. The MOUs did not create legally binding rights or obligations, and even if they had, they would have sounded on the international plane only. Secondly, the scope of the first MOU, both as to time and subject matter, is to say the least problematic. Don't worry about that, that was resolved. Thirdly, the Geneva Conventions do not advance the matter. Their only domestic legal effect is the criminalisation of grave breaches. That cannot support Miss Leaven's application for the issue of the writ of habeas corpus. Fourthly, it is very far from clear that the American authorities would accede to a request from the Secretary of State for the claimant's release. No such likelihood is entailed by the Geneva Conventions. The statement supplied by the US Department of Defence to the British Embassy on the 22nd of June, which asserts that the claimant remains under US control, subject to further reviews by a board of officers, might suggest, I make no finding, that they would not so release him. Overall, it is my judgment impossible to say that the Secretary of State is in a position, in effect, to direct the claimant's delivery. The claimant is not within his power and control. This case is beyond the amplitude of the writ of habeas corpus, whose issue accordingly would not be proper or efficient. Rather, it lies within the forbidden area of Abbasi and al-Rawi's cases. That is, it's entering into the terrain of international relations. And we can see that Mr. Justice Silver, as he then was, agreed. So those were the considerations that led him to say, no, there is not control. We then go on to the Court of Appeal, who overturned the Divisional Court's judgment. And that is at tab 11. And if we can turn to the judgment of the Master of the Rolls, as he then was, Lord Newburger, and to paragraph 44, page 409. And if the court can read that, where he again emphasises the factual nature of the issue of control. And then, before we leave the Court of Appeal judgment, if you can turn to page 410 and a heading, Discussion, the Diplomatic or Foreign Relations Aspect. Paragraph 47, and we can see there, he sets out the Abbasi case and the al-Rawi case. And if we can go to the bottom of that paragraph and start at E, assuming in favour of the Secretaries of State that the characterisation inappropriate is intended to support the point that the court is being invited to enter a forbidden area, it takes matters no further forward on that issue than the submission itself. As to that point, it may be said that the court should not issue a writ of habeas corpus in this case, as to do so would involve the court entering a forbidden area, because it would require the Foreign Office to make a request of the US authorities. That is, it would require them obviously to ask the US authorities to release, whether it be pursuant to GC or the Memorandum of Understanding. As I understand it, however, that point is not advanced by Mr. Eadie as a freestanding reason for dismissing the applicant's appeal. He contends that the point is really part of the case advanced on behalf of the Secretaries of State as to why the UK government does not have control, or why it does not at least have sufficient control over the applicant to justify a writ of habeas corpus being issued. And he then adds, I must confess to some difficulty with that approach. If, without taking into account that point, the government did not have sufficient control of the applicant, then his appeal would be dismissed and there would be no need to consider it. If, on the other hand, as I have concluded, without taking into account that point, the government does have sufficient control over the applicant, I find it hard to see why the point would justify reaching a different conclusion, i.e., if there is sufficient control as a matter of fact, then questions of forbidden territory play no part on the basis that the point was being advanced by Sir James at that point in time. He goes on, the point, if correct, that the court would be wrongly trespassing into the area of foreign relations would, as I see it, not take the question of control any further. The point would simply serve to prevent the court from taking a course which it would otherwise take. That is, to issue the writ and require the return. On that basis, then, if the point is not being taken as a freestanding argument, it cannot stand in the way of the applicant's appeal succeeding. And in my submission, that's a very important passage, and it's one to keep in mind in looking at the Supreme Court judgment, which again makes the same point, albeit in a slightly different way. Can we then turn to Lord Justice Maurice Kay, at page 412, paragraph 56. Oh, sorry. I'm sorry, before we do that, can I ask the court to read paragraph 50 and 51 on the following page, page 1489, into 411 of the bundle. then from there to page 412 and to the judgment of Lord Justice Maurice Kay, paragraph 56. If I can just ask the court to read that paragraph. And from there, could we turn into tab 12, please, to the Supreme Court judgment? And start in the judgment of Lord Kerr, paragraph 15, just a very short focus on the facts. He just makes an observation in paragraph 15 as to the asserted futility by the government's official, Mr. Parmenter, of requesting the US government to return Mr. Ramatulla on the basis that MOUs are the means by which courts have historically been invited to accept that the insurances which they contain will be honoured. And then paragraph 17 and 18.
Do we need these? I thought that
No,
was
don't worry. I just want to be sure. So I consider, therefore, that
That's the point where they
the
decide that the 2008 one doesn't matter.
Exactly.
Yeah.
So next, if the court can then move to page 438. And to the bottom of that page at H, habeas corpus. And if the court can read paragraph 41 all the way down to 44. Everything in our submission, which Lord Kerr says there about the nature of the writ, is extremely important and relevant. So starting with, the most important thing to be said about habeas corpus, at least in this case, is that entitlement to the issue of the writ comes as a matter of right. It issues as a right, and if detention cannot be legally justified, entitlement to release cannot be denied by public policy considerations, however important they may be. So if and insofar as control is established on the part of the respondent, then whatever public policy considerations there are that leads the Secretary of State or the respondent not to want to secure the release, they are irrelevant. The writ overrides that, and the writ requires that detention is brought to an end. The remedy of habeas corpus is said to be imperative, even peremptory, the top of paragraph 42. And classically, it's swiftly obtained, and as he says, this reflects the fundamental importance of the right to liberty. So, and that's also important because it's something, part of the reasoning of the Divisional Court, as we'll see later, that part of the reason that they reject the issue of the writ in this case is that it couldn't be, or release cannot be secured swiftly, and therefore that is a reason for the writ not to issue. And in our submission, that is looking at the matter backwards. And the point is that the writ marks the extent to which the liberty of the subject is prized by the courts, such that...
I can see why you're emphasising, but we have read it,
Yes.
and you're just telling us again what it says.
Yeah.
I see why you want to emphasise it, but I think we've got the point.
So I'll move then on to control. And at paragraph 45, at the heart of the cases on control in habeas proceedings lies the notion that the person to whom the writ is directed has either actual control of the custody of the applicant, or at least the reasonable prospect of being able to exert control over his custody or to secure his production to the court. And then he looks at Bernardo, and at the very bottom of that paragraph of Bernardo, he says, there was therefore a reasonable prospect that the respondent, despite his claims, either had or could obtain custody of the child, a purely factual question. He then goes on to look at the O'Brien case, and at the bottom, or rather at C on the following page, he says, on this basis, the Court of Appeal in effect held that there was a reasonable prospect that the Home Secretary could exert sufficient control over the custody of Mr. O'Brien to justify the issue of the writ.
These are all passages we have seen before, and of course they're endorsed by Lord Kerr, and that's important.
Yes, so it's the way in which he's endorsing it. What is he focusing on here? He's focusing on whether or not there was the possibility of factual control or evidence, a reasonable indication that the Secretary of State had, or Mr. Bernardo had, as a matter of fact, control. Then if we turn to paragraph 48, and there's important, I'm sorry, there is then the line, Scrutton and Lord Justice Scrutton and Atkin agreed with Lord Justice Banks, Lord Justice Atkin observing that the question was whether control exists in fact. Paragraph 48, and where it's already marked up, this highlights the factual nature of the inquiry that must be made as to whether a sufficient degree of control exists. It is not simply a question of the legal enforceability of any rights to assert control over the individual detained. The question is, as Lord Justice Atkin put it, whether control exists in fact. And then, if the court will turn to paragraph 52, with respect, the suggestion that the central feature of O'Brien was that there was no effective legal order is open to serious question.
Sorry, but this is all about Zabrowski, isn't it?
Yes, but he's then moving down and he's looking at O'Brien. With respect...
No, but the suggestion was a suggestion made in Zabrowski.
Yes, that the central feature of O'Brien was that there was no effective legal order is open to serious question. A critical, if not the central issue in that case, as I have sought to demonstrate above, is that there was no reason to conclude that the Home Secretary had control over Mr. Bryan's release. Habeas corpus was issued in that case not simply because it was held that he'd been deported and interned in foot of an order, which it was found had not been lawfully made. The issue of the writ depended crucially on the finding that it was likely that the Home Secretary could procure Mr. O'Brien's release. And then, paragraph 59, Mr. Eadie argued that these observations illustrated the impropriety of courts giving directions to ministers.
Which observations are these?
Sorry, I'm where it will become obvious from the text that follows. I'm not taking your
fair enough.
The court to them, just to save time.
Fair enough.
I'm trying to focus on what the court said. Mr. Eadie argued that these observations illustrated the impropriety of courts giving directions to ministers as to how they should conduct affairs of state. It was inappropriate, he said, for the Secretaries of State in the present case to be, in effect, instructed to ask the US authorities to return Mr. Ramatulla. Whether the UK government would have resort to the political agreement in the 2003 MOU was a matter of political judgment, and the exercise of that judgment was not a matter for the court. So it squarely non-justiciability, forbidden territory, international relations was put in issue here in respect of the Secretary of State making any moves to secure the release. The writ in this case had a singular effect, Mr. Eadie claimed, of requiring the Secretaries of State to engage at a diplomatic level with the custodian state, the US. And then Lord Kerr rejects this. I do not accept this argument. And if I can ask the court to read the rest of this paragraph.
Yes.
And the important observation there is in the last 4 lines of that passage. We can then move to paragraph 63. If I can ask the court to read paragraph 63 and 64.
Yes.
And then, if the court follows through the discussion about foreign affairs that then follows, where Abbasi is referred to and discussed, down to paragraph 70. Neither issue, and again, I apologise for not taking the court.
Well, I think I do want to see what the issues are that are being referred to, but they're easily enough in the previous paragraph.
They are. So it's the forbidden territory.
Yeah.
Neither issue arises on the present appeal for the reasons that I have given in paragraphs 38 to 40 and 53. The legality of the US's detention of Mr. Ramatulla is not under scrutiny here. And if the court can then carry on and read through.
Yeah. How far? To the end of 70?
To the end of the paragraph, please.
Yeah. Yes.
And importantly, because they appeared to have the means of securing Mr. Ramatulla's production on the foot of the writ of habeas corpus, they were required to bring that about or to give an account of why it was not possible. So no question that whatever they felt at a diplomatic level, they were required, once the writ was issued, to bring about the consequence of securing his release, if in fact they did have control. And can I then ask the court to read paragraphs 71 to 74?
Yes, just give me one moment.
Do we have in the bundle, I'm sure we do somewhere, a copy of what the writ would look like if issued?
There is a standard form in the white book, so we can give the court the page reference.
Thank you. 70,
So
71, 72 you want us to read?
71 right down to 74, because
Okay.
in my submission, that those paragraphs make absolutely clear that that is the consequence of the issue of the writ.
So what is the consequence of the issue of the writ?
consequence is that which was set out at the end of paragraph 70. because they appeared to have the means of...
Well, why don't we read it first,
Yes.
and then you can tell us what we get out of it. Yes.
So, in my submission, not only does this make clear the distinction between judicial review and habeas corpus, it also makes clear what the effect of the issue of a writ of habeas corpus is. So where the court is satisfied that the writ should issue because it is satisfied that the respondent has control, or there's reason to believe the respondent has control, then the consequence of the issue of the writ is that the body must be produced. The persons released must be secured. And that must be done by the return of the writ, irrespective of whether the Secretary of State, in this instance, doesn't want to do it in the exercise, and if in the exercise of his discretion in this instance, to provide consular assistance as the means by which to secure release, it would be lawful for the Secretary of State not to exercise that discretion. The two are fundamentally distinct, and that discretion does not exist in habeas corpus. In habeas corpus, the issue extinguishes that discretion and requires the respondent to secure the release.
Can I just ask for your help with this, Ms. Kaufman? What's the consequence of that for what one might call the hostage situation, where a rogue state has unlawfully seized a British citizen? And there's absolutely no doubt that they will very willingly surrender him to the UK authorities, but they want £10 million to do so for the express purpose of buying more ammunition to continue their insurgency in which British citizens are being injured and killed. In that situation, it could no doubt be said, on appropriate facts, well, of course it's in the control of the UK government. All they have to do is pay the money and he'll be home tomorrow. I understand entirely the distinction drawing between habeas corpus and judicial review, but what are the consequences of that distinction for a situation such as that?
Well, on the basis of this authority, of Ramatulla as it stands, then that is something that the Secretary of State would be required to do.
Almost seeking to distinguish the two situations. One might say that in Ramatulla, and the same is true in O'Brien, the UK government was the original detainer. The only reason why the claimant or applicant for the writ is in the control of someone else, or in the custody of someone else, is that the UK government has released them to that. In the case put by my lord,
that would not be so. Isn't that an important distinction?
Well, in our submission, no, that is not a distinction. It's a factual distinction, but it wasn't a condition precedent to the issue of the writ or in the judgments of any of the Supreme Court.
Well, that's because those were the facts. The question didn't arise there. In one sense, it was a condition precedent, because the condition precedent for their reasoning was the existence of the MOU, and the MOU was precisely about a situation where the UK government was the original detainer, but passed the person to the custody of the US authorities. So it was fundamental to the situation which the Supreme Court was considering.
Well, certainly it was relevant factually. There's no question it was relevant factually, because the question, the de facto question of control, was answered by reference to the power that existed by virtue of the MOU, or the duty that existed by virtue of GC4.
But no decision exists in a vacuum. All these observations about de facto control are in the context of a situation where the UK government was the original detainer. And it doesn't seem to me to be obvious that they can be extrapolated and put into a completely different situation, where the UK government had nothing to do with it. But is being told they can have their national back for payment of a sum of money.
Certainly, for Lord Reed, it was the case that the fact that he had been in UK detention was for him a critical factor.
Yes, well, you're right. We, in a sense, my Lord asked this question at an appropriate time, but I followed it up a bit prematurely because we haven't yet got to the judgments of Lord Reed and Lord Phillips.
Lord Reed and Lord Phillips, exactly. So
well, let's park that, but you're going to have to tell us at some point why they were wrong.
Well,
so let's try and do it after you've taken us to it.
Yes. I think what I'll say is, rather than why they're wrong, why their reasoning does not form part of the ratio of the decision is more what I'm going to submit.
Well, you have to go further. You certainly have to say that, otherwise you're stuck. But you'll also have to say they're wrong. Because if it was not part of the ratio but was nevertheless highly persuasive, we clearly not bound by it, but we want to know why you say they weren't right.
Well, I shall certainly address
okay. Well, let's finish with unless my lord. I didn't mean to take over from my lord's point. Your answer was straightforwardly and consistently with your submissions that in that situation, whether it was 10 million or 100 million, we could pay the money, and therefore it's the hostage is in our control.
That's certainly my immediate answer, but as to whether I come back with something more considered, I hope the court will give me an opportunity to think that over, but certainly it is consistent with the question being one of factual control. So that's the judgment of Lord Kerr, and then if we can turn to the judgment of Lord Phillips, where
So Lord Kerr is in fact agreed with, it's a 7-person court, and Lord Kerr is agreed with by 2 others. That's right, isn't it?
He is, and Lord Phillips agrees with him, but subject to the concerns that he has about the unexplored issues. So we'll see how he puts it, but certainly Lady Hale and Lord Carnworth agree with Lord Kerr, but they dissent on whether or not sufficient steps have been taken to ascertain whether or not the US did in fact have control.
Yes.
So if we can turn to the judgment of Lord Phillips, which starts at paragraph 86, and turn to paragraph 97. At 97, we can see he refers to the unexplored issue. If the court could just read that paragraph. And then all of paragraph 98, where he sets out the result and the basis upon which he agrees that the appeal should be allowed. Dismissed, rather.
Yes.
So again, he makes clear that if the writ issues, then issues of diplomatic relations and so forth simply don't have a role to play. But he is concerned about the unexplored issue, and that then forms the detail of his following analysis, paragraphs 100 onwards, and then if the court would read paragraph 106.
Yes.
So there he sets out matters that he does not consider have been addressed and might make a difference to the outcome. And he then asks the question, and if domestic law does provide Mr. Ramatulla with a remedy, is this the extra set of habeas corpus, which pays no regard to forbidden territory? Again, making it clear, it simply does not have a role to play, or does the remedy perhaps on judicial review and the doctrine of legitimate expectations?
Well, hang on. Is that the most important passage for the purpose of point I was putting to you? Isn't it more 104 and 105?
Because the context of those observations is what Lord Phillips said in the middle of paragraph 98, where he posits a counterfactual. Imagine United Kingdom authorities unlawfully seized Mr. Ramatulla, clandestinely transported him to Afghanistan, and there handed him over to the United States forces. Imagine that before doing that, they entered an MOU that the US would agree to hand him back. Imagine there was uncertainty as to whether the United States would comply. Imagine the UK, in the interest of good relations, did not wish to request the United States to do so. I would have had no hesitation in those circumstances in applying the O'Brien approach. So that's the context in which he makes the observations to which my Lord has just drawn attention.
Yes.
The structure 104 and 105 is premise. Surely nobody could suggest, except possibly the Federal Court of Australia, that the mere fact of having control was enough if you hadn't detained them in the first place. And then 106, to which you took us, says, well, actually, this case might be more like that. But it's not 106 that creates the difficulty for you, it's 104 and 105.
Yes, no, I understand the limitations, and he sets out the limitations of his judgment in the passage I took you to. I was coming to 106, because our position is this judgment, the judgment of the Supreme Court overall, if you look at all the holdings overall, lays down a test of de facto control and does not lay down any more restrictive test for control.
But it lays a test of de facto control in the circumstances of the kind that were before the court, where you once had detention. Sorry, you once had actual custody, having been responsible for the original detention, and pass it over to someone else. The test in deciding in those circumstances whether you can ask for the person back is one of de facto control. That's absolutely clear, as you rightly say. But it doesn't follow that the test is one of de facto control in a quite different sort of situation, and Lord Phillips and Lord Reid made it clear they didn't think it was.
So our primary case is that it does simply
Yes.
lay down a test of de facto control. Okay. Our secondary case, set out in our supplementary submissions, which I will come to, is one that arises where it is considered that something more than de facto control is required. And that is concerned with our supplementary case.
Yeah.
What more is required? But our primary case is that Ramatulla establishes that all that is required is de facto control. And the circumstances in which control is acquired are not relevant. It's simply a question of, can you secure the release?
But there's nothing even in the majority in Ramatulla which says that little bit that you slipped in, irrespective of the circumstances in which control is required. Most you can say is, control was acquired. The most you can say is that they didn't put in any qualification about the circumstances in which control was required.
Absolutely. They put in no qualification. They did not focus at all on the preconditions that have to be met if de facto control is not itself sufficient. And that we submit.
But if that's right, then the qualifications made by Lord Phillips and Lord Reid in their judgments are correct, aren't they? Because there's no express reasoning in Lord Kerr's majority judgment which deals with the point that they identify.
Well, we need to come on to look at the judgments of Lady Hale and Lord Carnworth. And our submission is, when you look at all the judgments overall, that is the totality. Because that issue was raised, and it was an issue that was deemed not to be of particular concern.
Well, let's return to that consideration when we finished, because I think we've now seen what Lord Phillips said, but we ought to see what Lord Reid said.
We need to see what Lord Reid said, and then Lord Carnworth and Lady Hale's judgments.
Yes.
So there's not a great deal, so we can certainly get through those.
Yes,
so
well, let's do that.
Lord Reid, paragraphs 109 to 114. If I can ask the court to read all of that. As well as 115.
Yep. Sorry, it may sound I've read it, but you won't be surprised to hear I've read it before, and I know my lady has as well.
So he does state in terms of 115 that there are two considerations there. One in particular that is important for him, and that is the fact that he was initially detained by British forces. So that the question was whether or not control had been relinquished. And there's this important passage. But for that factor, I will find it difficult to see why the English courts should entertain an application which would otherwise have no real or substantial connection with this jurisdiction. Now, when we come to our supplementary argument, I will come back to that passage.
Yes, and you're right. It's fair to say that that's a slightly different reason for saying it was important than the one that I was putting to you.
Yes,
And
it's
that
the
possibly-
connection. It's a real or substantial connection that he's concerned to identify. And we will come back to that. And then he raises the issue about whether or not there needs to be legality. And that issue, it was raised by Lord Phillips, or illegality on the part of the UK.
Yeah.
And certainly was not an issue that was of concern to the judges in that case. And that's also clear from Lord Carnwath and Baroness Hell's judgment that then follows. Can we then look at Baroness Hell's, their judgments, starting at paragraph 116?
Well, we don't. Do we know what the attitude of Lord Kerr and those who agreed with him to this point was? Because they don't express. I mean, Lord Kerr doesn't expressly deal with this point.
No, Lord Kerr doesn't express.
No.
No, exactly. I mean, sorry, my lady, are you talking about illegality? Because there was no evidence of illegality on the part of the UK. So it's quite clear that illegality and the need to establish illegality on the part of the UK was not something that was required and is part of the ratio of this decision. It wasn't considered, and that was a concern for Lord Phillips. But it wasn't a concern for the other judges.
Right.
There was no. What is different, but is the case, is that there wasn't express consideration of whether or not it was necessary for there to have been prior detention, for example, or in the words.
Yes, am I being slow? I mean, that Lord Phillips's unexplored issue is not quite the one
No, they're
that
different.
I'm putting to you.
Yes, they're different. So his unexplored issue was, is it necessary before the writ can issue that the respondent to the writ must have acted unlawfully?
Quite.
So in Mr.
But part of the route by which he gets there is that no one could suggest that if there hadn't been a handing over and the foreign government was the initial detainer, that habeas corpus would lie. That's the point that interests me.
Yes, that's a separate point. So I just want to be clear that we're dealing with, there are two
Yes.
issues there. One is illegality on the part of the respondent in respect of the detention. And that was not explored at all. Your point is, while it wasn't explored, this is nonetheless potentially a critical component, that there was some prior detention, some engagement, something in relation to the detained person on the part of the respondent. And our submission is
You say that's not essential.
that's not essential. So if I can just ask the court to look at paragraph 116. I agree with him, the Secretary of State's appeal should be dismissed, but we differ respectively on the cross appeal.
We needn't bother with the cross appeal.
No, we don't need to worry about the cross appeal. So can we look at their not being concerned with the unexplored issue is at 121. And then if the court could just read down to 123.
Yes, well, 122 is not helpful to you, is it?
Well,
Basically, they're saying he's obviously right in para 105.
yes, that it's not a persuasion case. This is not a persuasion case.
Well, I think they're talking about persuasion, are they?
Might
I
be
see
in a
they are
position to
using the
persuade
word.
the
They are,
US
but using the word
police.
persuade. Yeah, but the key point is that You've got to read it with the next sentence. The point.
Yes. This is. There is nothing inconsistent with that next sentence. That as a matter of fact, by reason of the obligations that arose, whether legally enforceable or not, they had the power to secure release. Contrast a persuasion case where all you can do is ask and influence. That's the essential distinction they're drawing there.
Yes, but the point about the simple ground, if you read in context, is that there is no element of prior detention. That's why it's a simple ground. All you've got to do is the power to influence.
In my submission, can I just come back to 105? Well, in my submission, it is not clear, if you put the two paragraphs together, that what they're saying is that what distinguishes this case from the example that Lord Phillips gave in paragraph 105.
If you read 105 with 104, it says at 104, it seems to be at least questionable whether a claim for habeas corpus would have succeeded if the authorities of the Irish Free State had seized and imprisoned Mr. O'Brien on their own initiative, but were likely to be amenable to a request for a release.
But again, that's
so the whole situation being considered in 104 and 105 is you didn't do the detaining, but you have the power to influence the release by the power who did detain. And that's what's being picked up in 122, and as I read it, Lady Hale and Lord Commonwealth are agreeing with that, saying, but it's not the case here, because in this case, the UK was the original detaining power, and that as such, it has continuing responsibilities under GC4, which led to the making of the MOU. But that's how I read both Lord Phillips and Lord Commonwealth and Lady Hale, insofar as they're agreeing with Lord Phillips.
Well, can I come back to that tomorrow morning?
Yes, of course.
In my submission, that is what is being distinguished there is a situation where there is a mere ability to persuade from a situation where there is a power arising from some form of obligation or agreement, the MOU or GC4, that enables the respondent to determine whether or not the person is released. And that the fact of prior detention is not something which was critical in the reasoning at 122.
No, thank you. Certainly you're entitled to say that it was all rather shortly discussed, insofar as it's discussed at all, because for different reasons they accept it doesn't. It's not the facts of that particular case. Hang on 1 second there.
So, my lords, my ladies, is that a good time to stop? Because I think we're in good time. I need to very quickly summarise the case law, come back to the court with anything that we think of overnight in response to some of the questions, and look at the Divisional Court's judgment and where it, or summarise the case or apply it to the facts of our case, look at the Divisional Court's judgment, and then move onto our supplementary case.
No, I think that is a good place to stop. But can you just also be thinking about this? It rather seems to me, from particularly what Lord Phillips says, that the reason for it being essential that the respondent to the writ is the original detainer is likely to be reinforced by looking at the historical origin of the writ. Of course, a point you've made in a different context, the writ can develop over time. But unless I'm told to the contrary, it seems to me apparent from the limited reading I've done, including these authorities, that its clear function is where a person, clear original function, where a person, most typically a government authority, authority, though it can, I appreciate, be any authority, is detaining someone, that they must justify their act of detention. And it's about the abuse of power effectively by authorities within the jurisdiction. And the cases which we've been looking at are merely extensions of that, where, having done the original detention, they have passed a degree of, passed actual custody to someone outside the jurisdiction. That's certainly the case in Ramatulla and also in O'Brien. But that those are merely particular extensions for a particular reason of a writ which is ultimately concerned with restraining unlawful detention by domestic authorities. And anything in the history which shows that I've misunderstood the original reasoning of the writ might help you. So I thought I'd raise that now. People are going to be burning some midnight oil.
I'm grateful.
I'm not asking for a whole historical treatise, but just in case you want to undermine that point.
We will.
Very well. So you think, it's obviously, I'm not holding you to any prediction like you, I think we seem to be making good time. But you're going to finish sometime in the course of the morning, aren't you? Probably earlier on than later. Yeah. And Sir James is always quick. Just said that to set a test.